Hello friends, Mandar here. I'm back with another video. Today we are going to talk about FY 2022 H1B cap, what is happening with that. We'll also talk about some of the USCIS alerts that have come in regarding adjustment of status and upgrades and things like that. We'll cover some of the points that you can do in order to have USCIS take some action on your case if your case has been pending for a very long time. And then we'll do some speculations about what's to come in the upcoming months for the visa bulletin. So I'm pretty sure most of you will be interested in one or more of these topics. So stick around until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Now the spring is here after a long winter, especially in the northern part of the country where we received a lot of snow this year and a lot of cold temperature. It's welcome news to see the spring. Here in the New England we have seen a lot of spring-like days and hope to continue to see improving weather in the next couple of weeks. We are fortunate to have 4 distinct seasons in this part of the area, which I love. But anyways, I also had a giveaway announcement in my last video. If you haven't checked it out, please do check it out. One lucky winner has got the Google Pixel 6 Pro phone and it's in the mail. I'll continue to do these giveaway announcements every month, so if you haven't subscribed already, please do subscribe so that you get those notifications about those announcements. And now the time for the sponsor of this video. Now, have you ever wondered that you might be able to mask your IP address? You might be able to show as if you are in a different country and watch Netflix, Amazon from a different country. Especially for people in India, you know Amazon India and Netflix India, lot many other shows that you might not be able to see here in the US. So what do you do in that case? And that brings me to the sponsor of this video, which is Surfshark. Surfshark is a VPN provider and that gives you a lot of benefits that you are looking for. Now here is what all Surfshark has to offer. It gives you the power to protect your online privacy, control your personal data, access content safely, and unlock the exclusive benefits of this. What else can it do? You can browse privately, encrypt your internet activity so that no one can steal or track your data, hide your location. This is the key when I was talking about being able to watch the Netflix and Amazon from different countries. Block ads and malware, stay safe on public Wi-Fi, keep searches private, and get real search results. And if you are in the tech or IT industry, you know what VPN can provide. Now if you click the link in the description with my code Mandar, you will get a discount, almost 83% discount on VPN deal and plus 3 months of absolutely free VPN. So check out the link in the description, and if you do get the Surfshark through my discount code, it will also benefit the channel. Now let's dig into our topic. Now the H1B cap petition started this year on 1st of March and they had the timeline until 18th of March to submit your first round of petition. So basically you just pay $10 of fee and get your name and basic information in from the petitioner, and that's how you get into the pool of lottery. Now the first few decisions have started coming in as I hear, and people have started announcing that whether they got approved or not, or whether they got selected for the next round where they will ask you to submit the full documentation. Now one another interesting thing this year is USCIS is not so happy about these multiple filings that have been happening in the last couple of years. Now although they haven't specifically stated that they will ban these kind of multiple filings by different companies, it is really not a very good idea, and I have been saying this in my many videos in the past. How can you apply for your H1B petition from several different employers? So it is misrepresenting in a way in my mind. So you are taking away the chances of others who have a legitimate job and they are trying for their H1B petition this year. Some of them might be end of their third year of OPT, and they are really on the timeline. And these junk petitions which have been filed, like not one, not two, like 10 or 15 that I hear about, with just a $10 fee, a lot of people are going through multiple consultants and applying for this H1B cap subject petition, and it is really taking away the chances from the legitimate applications. So USCIS is not also very happy with this scenario. They had put in an alert and on their website, and I think they are going to come very strongly against it in this type of scenario. So that's all I wanted to say about the H1B cap petition this year. So now the second round will start when they ask you to apply for the full application, and then if they did not get enough applicants because of these multiple filings, they might have the second lottery somewhere in July timeframe. So but we'll see what happens. Now the second point I wanted to cover is there are a couple of USCIS alerts that they have put in. Now with the progression of EB2 date by 1 full year, they had put in a lot of alerts in the past several days. I have signed up on Twitter for USCIS, and I get these alerts as well. So let's see what they say in some of the recent alerts that have come across. Now the first one says, if you are applying for adjustment of status, please file Form I-693 report of medical examination and vaccination record together with I-485 application to register for permanent residence. Doing so may eliminate the need for us to issue an RFE. So this is nothing new. I have always told my viewers that if you are applying for I-485, go ahead and apply for 693, which is medicals, right at the time of the application. What happens is that way you don't have to you don't receive an RFE, and you don't lose that time in between in responding to RFE, because they already have your medicals available. And now they have also extended the medical validity for 4 years, I think 48 months. So if that is true, then you don't have to worry about the medicals getting expired, because they can be expensive, about $400 to $500 per person. But once you do it at the time of applications, you are set for the term of your application. As long as your date remains current, you should have your green card within the next year or so. That is one of the alerts that we got from USCIS. Now let's look at the second alert, what it says. It says, if USCIS does not approve a Form I-485 transfer request, then the adjustment of status application will remain pending on its current basis. A denied transfer request does not result in the denial of the pending I-485 situation. So let me explain this further. So if you have your downgrade petition, if you have your EB3 petition in progress at USCIS, and then now that the dates have progressed for EB2, now you decide that now your date is probably current in the final action date chart, and you decide to upgrade your petition from EB2 to EB3. Now if you do the change of underlying basis, which is what is the fancy term for interfiling from EB3 to EB2. If you do that, and if your change of basis is denied, what USCIS is saying is, don't worry, your underlying original I-485 based on EB3 will still remain in the process. So it doesn't mean if your upgrade interfile gets denied, that your EB3 also gets denied or something. So that's not the case. So even if your upgrade interfile gets denied, your underlying I-485 based on EB3 will still remain in progress. So which is a good news. So in this case, you don't have to worry about applying for interfiles. Just go ahead and do it if you are eligible for it, and you don't have to worry about that getting accepted or not, because your EB3 is still in progress. So which is good news. Now let's look at one more alert that I wanted to kind of highlight here. This is the third one. As a reminder, submitting a new adjustment of status application is not required to transfer the underlying basis of pending Form I-485 and will not result in a faster adjudication of benefit request. So this is something that USCIS is now coming out and saying. So remember, in the past couple of videos I have said that you have several different options if you want to upgrade. One is the interfiling, the normal interfiling. So basically sending your upgrade petition to the same office where you submitted your EB3 petition. That is one. The second interfiling method is this new process that USCIS did put in January alert, which says that you have to send it to a California Dropbox location, from where it will be then tied it back to your EB3 petition. That is the second method. And then the third method is if you can file a fresh I-485 based on your EB2, approved or in process EB2, which will be a parallel application to your EB3 pending petition. Now what USCIS is saying that they don't want you to apply for a separate I-485 application, they just want you to upgrade it. Now the trouble I have with this is we haven't seen any progress on these interfiles, right? So this has been in the last several months. We are hearing that USCIS wanting everybody to upgrade through the interfile. So maybe they are taking a little bit longer, but we don't have that warm fuzzy, that confidence that those interfiling from this new process at California address are going to the right place, and they are being upgraded and they are being processed. So we don't have that. So in the meantime, some people are wanting to just submit it as a fresh application, which will be in parallel of EB3 application. So do what your lawyer has to say. Talk to your lawyer, talk to your company, say what they are going to support it, because USCIS is coming out and saying now that they don't want to see a separate application for I-485. They just want people to interfile, and they are confident about that process. So take it for what it's worth. If USCIS is saying it, you might just want to listen to them and just do the interfile. Again, as remember, there are two ways to interfile. One is to submit it to the same address that your EB3 was submitted, and the second one is through this California address. So you have to pick between the two as well. And if you want my opinion, check out my last video where I go through all different scenarios and which would be my preference if I was in your shoes to upgrade the petition. So check out that video as well. So after we look at these alerts, now I want to talk about some of the options that you have in case your application has taken way too longer. So a lot of people, even in EB1, EB2 and EB3, all categories of EB, sometimes what happens is people apply for their adjustment of status, and their date, even though their date remains current throughout the processing, it just takes very long time. We can understand if your date retrogresses since the time you applied for 485, which happened with EB3. Now you're just sitting and waiting for your date to come back current, and that can take multiple years, and that is understood. But in the other cases where your priority date remains current throughout and still you haven't got your green card, there are a couple of things that you can do. One is proactively submit your I-693 medicals. The reason I'm saying this is because even if you have not submitted it at the time of your 485 application, which some lawyers don't suggest to apply, they just ask you to wait for the RFE. Then in this case, if you have waited long enough, say for a year or year and a half, based on your pending I-485, and if your date has been current all along, then you can proactively submit your I-693 medicals. What that will do is that will kind of trigger USCIS to look at your application. So once they get their medicals, they have to attach it to your application, and while they are doing so, they'll see, okay, your date is current, so why not just approve this petition? So that might, and that has happened, and I have received confirmations from a lot of people who I had suggested to proactively go ahead and submit your medicals, and they have gotten their green card in the next couple of weeks. So this sometimes works. It's not a guarantee that it will work, but it works many times. And this may not be an option for people who have already submitted your medicals. So this might be a redundant option, but something to consider. The second one is Ombudsman Request, and I have provided the link in my previous videos, and I'll put this into my description as well. But Ombudsman case, they allow you to submit an inquiry and get your status update on your case. So in this way you can also nudge USCIS to look at your case, but this only works if your processing time has crossed the suggested processing time for that particular service center. So if your case is at Nebraska or Texas or California, and if the processing time has passed, say beyond, if the normal processing time is say 12 months or 14 months, and if that amount of time has passed, then this ombudsman request might work. So that will kind of trigger USCIS to look at your case, and that can get approved within a reasonable time. Another one is, as usual, many of you know, contacting your senators or congressmen, sending them a letter. They typically have a service on their website where you can ask for a USCIS update on your case. So that I would say that works only 50% of the time, not much. You can't rely much on that. Some people have good experience with that, but not many others don't have a good experience with that. So that's just a couple of ways that you can nudge USCIS to look at your case if significant time has passed. Now, there is no way to expedite your actual green card processing. Maybe your underlying EAD or AP, if that is taking too long, there is a way to expedite that by giving a proper reason. But your 485 in itself, there is no way you can expedite, because it is at the discretion of the visa officer. They can say it's just going to take long because we want to check your background and whatever, and they're not going to entertain your expediting of green card. But your EAD and AP can be expedited if you have a valid reason for doing so. Now, many people have asked me what is the speculation for the next couple of months. Now, we have seen a lot of swings in USCIS. So remember, in last 2 years back, it was EB3 where they progressed by about 2 years, and then they realized their mistake, then they retrogressed by 1 year, and then more retrogression by 2 years. So they kind of did some aggressive forwarding of the dates for EB3, and then they retrogressed by almost 3 years. So if you remember, they had progressed it to 2015 January at one point in October or November 2020, and now it's back to 2012. Now they are doing the same thing with EB2, but this time I think EB2 might be a different story. They have progressed the date for filing by 1 full year, and my speculation is since they have a lot of visa numbers available for EB2, they are going to meet that date of September 2014 by end of this year. So if they do so, they are going to have to process a lot of visas or green cards in the next 4 or 5 months until end of September. And my speculation is they are doing their best to use up all the visa numbers for this year. But I made a special video on how many visa numbers could be wasted this year, and you might want to check that out. I say in the optimistic scenario, they will still lose maybe about 50,000 visa numbers this year, but it's still significantly higher than number of visas that they will be processing year over year. So my speculation is in the next few months, file an action date chart for EB2 India is going to progress significantly, and it will probably meet September of 2014 by the end of this fiscal year, which is September 2022. So that is just my guess. Now, a lot of confusion over the clock resetting thing. Now people are coming back to me about this reset of 180 days if you do your interfile from EB3 to EB2. In those cases, there are two things that I want to try and find out. USCIS clearly says on their website, and I have sent it to multiple people, and I will probably just put it in the description as well, that if you interfile, your clock resets for 180 days for AC21. If you want to take advantage of AC21 job portability, and if you interfile, your date is likely to reset. Now some lawyers argue because they have the power to litigate it, to challenge it in the courts. So they will certainly tell you that you don't have to worry about the date reset. My interpretation is, if you are upgrading your petition based on an already filed and approved I-140 from the past, it is likely that USCIS will not reset your date. But nowhere on the website do they say this particular thing. I only tell what USCIS rule says on its website. I will never tell you anything else. So do remember, do talk to your lawyer in that situation. And it's only a matter of 180 days. If I were in your shoes, I would not change a job within those 180 days. You have waited for 10-15 years for your green card. And what is the rush for you to change your job within that particular window of opportunity, right? when you upgrade from EB3 to EB2, why can't you just wait for 180 days and then do the job change, right? Why do you want to get into that ambiguous situation where USCIS might reject your application or might not, or if it might be okay? If I were you, I would not get into that situation. I would just wait for 180 days and then change my job. I know the job market is very hot. People are getting new job offers left and right, but it's up to you to decide whether you want to change your job within these critical 180 days period after you upgrade your petition from EB2 to EB3 even through interfile. So that's your choice. So that's really all I wanted to cover in this topic. In the future videos, I'm actually going to talk to immigration lawyer from Canada. So I get a lot of questions about Canada immigration and moving to Canada from the United States, because some companies are allowing people to work from Canada even being in their current role. So there are pathways to move to Canada and settle over there, and I'm going to talk to a Canadian immigration lawyer on 5th of May at 4 o'clock. So I'll be having a live session with a Canadian immigration lawyer and another company who is also supporting individuals to move from US to Canada within their same job or through a new job. So I'll be talking to both of them on 5th of May at 4 p.m. EST. So mark your calendars if you are interested in this topic. They are going to cover a lot of important things that you might be interested in. So that's all really I wanted to cover in this video. If you like the content of this video, please hit the like button and consider subscribing to my channel, and I'll see you in the next one.